Good afternoon, everyone, and a very warm welcome to our first webinar in the series Unlocking Development Potential. I am Parnjit Gill, partner and head of the commercial property team here at Harper James, and I am joined by my colleague Abdi Ebrahimi, a partner in the team. Today we are going to talk through identifying the right site and going back to some basics. You may have located a site via an agent or a brochure. Please do not assume that the information is accurate, especially when it comes to the title plan. I would strongly advise that you contact your lawyer so that we can verify the property and the seller's details for you. The next step would be arranging a site visit, and I would advise that you do this a few times at different times and dates so that you can gauge activity within the vicinity of your proposed site. Some of my clients find it useful if there are a couple of you that attend a site visit and take photos. Once out on site, what should you be looking for and what are some of the material red flags, which is what I'm going to be running through. There are going to be a few images which will illustrate some of the red flags I'll be discussing. Turning to public and private rights, what do these look like? Looking at public rights first. Along the boundary of the site, have a look to see if there are any gates or any openings or even a well-trodden path in the ground. What is the gate for? Or what's the opening for? Could it be used as a cut-through route for walkers or dog walkers? If so, try and ascertain how long this has been the case. Could this be a public right-of-way? Can you see any signs? Are these covered by overgrown hedges or bushes? Look at where the pole sits for these signs. Is this within your boundary or is it running alongside on the outside of your boundary? Now, this doesn't immediately mean that your site is blighted. Depending on your development and scheme layout, could you make this work? If, for example, the public right-of-way is on the boundary and you are intending to develop houses, could you design a scheme around this? One of my clients did exactly this. Financially, the figure still worked, notwithstanding the loss of land, to a public right-of-way. If, however, this is running in the middle of the site, then this might be a little trickier as you may lose too many plots, which will affect your appraisal and profitability. Turning to private rights. Now, these may not be so obvious and may need some detective work on your behalf. Looking around the site, are there any maintained areas that are visible to you? Does it appear or seem that someone might be looking after a particular patch? If so, could this be as a result of the seller agreeing for a friend to access and use this land? And if that's the case, how long has this arrangement been going on for? What we don't want is for a third party to argue that they have acquired rights pursuant to this innocent arrangement. We want to ensure we can get vacant possession. If this arrangement has been documented, then ideally we want this document to state that no rights have been accrued and that this arrangement can be terminated. If you are looking at land opportunities in the countryside within the vicinity of greenbelt areas, then it wouldn't be unusual to find grazing licenses for animals in place. Now, for the seller, having these in place is a win-win. The land is maintained coupled with a regular income. For a buyer, perhaps, that's not so good. Aside from the issue around rights and procuring vacant possession, it is worth bearing in mind that as part of your planning, you are going to have to submit a number of reports. And if one of these is an ecology report, then the presence and use of fertilizers in the soil could pose an issue for you. This is one of the reasons why it is so important to agree access to the site so that you can undertake site investigations. Now, looking around your site, are there any buildings that you can see? We need to understand, are these empty or are they tenanted? And what are they being used for? Are they listed, for example? Could there be grade 2 listed buildings? And more importantly, what's the access to and from these buildings? What we're trying to do is ascertain information that allows us to build a picture. Another consideration is the presence of any walls running along the boundaries. Has the seller ever had to do anything with a boundary wall? Here, what we're trying to work out and ascertain is, could this be a party wall? If it is, and you need to do any works to it, then you need to appoint a party wall surveyor and follow a very detailed set process around party wall agreements. and any works that need to be undertaken. This can be costly and time consuming, especially if your neighbour decides not to cooperate with you. Now, turning to highways. Whilst on your site visit, this is going to be one of the most aspects of your development, is how you access and egress from your site. Will this be from adopted highway or a private road, or is it half and half? Are there any grass verges or gaps between the highway and your site? If so, is this in the ownership of a third party? Could we possibly have any ransom strips, which we need to look into? And this is something Abdi is going to go into a little more detail shortly. This is one of the reasons why we undertake highway searches. It is to ensure that the boundary of the site abuts the adopted highway. Whilst looking at highways, also look around for any load or construction traffic restriction signs. This could impact development timings and costs. Will your contractors be able to get your construction traffic, plant and equipment through without highway restrictions? Also, look around and see if there are any other houses or buildings. If so, in order for owners to access these homes or buildings, will you need to keep vehicular traffic flowing in order for them to access their properties, but more particularly during your build phase? The presence of highways and the location of other buildings also indicates that there is a possibility you may be able to pull through services from the highway to your development, for example, drainage or gas, subject obviously to engaging with the relevant authorities and following the protocols. Now, going back to the very beginning, when I suggested that when you go out on site, you contact us and you take an official copy plan. Sometimes the boundaries may not be clearly identifiable on the ground, so these may need to be marked on site. Or you could be in a situation where very casually the seller or the agent may comment that the land that sits over there, pointing at some bare land, that they are all happy to include this in the sale. It would be useful for you to mark this on the plan and share this with us. And what we'll do is we want to ascertain whether the land is registered or unregistered. If registered and the seller is the registered proprietor, that's great. However, if not and the land is unregistered, will the seller be able to evidence ownership of this land, which is satisfactory to the land registry? Now, a few things to bear in mind around unregistered parcels. It is not uncommon for the land registry to register these parcels with a possessory title. The best class of title is absolute, which is what we always look for. There are ways that the class of title can be updated, but that can be a long process. Now, the reason why this is important is because if you decide to include this land in your proposed scheme layout and you or your ultimate plot purchaser is procuring funding from a lender, then this is going to come up as a material flag, which we will need to mitigate. This may be by way of insurance policies, but that all depends on the lender's appetite for risk. For plot purchasers, it could also affect the mortgage offer that is made to them. I mention this as it is important to keep the whole transaction on your radar. We ideally want to be mitigating risks not only at the outset, but also at different stages of your development cycle for you, your lender, and your end user of your development, as that's your exit strategy. Now, turning to other irregularities whilst you're out on a site visit. Are there any telegraphic poles? Do you need to move these? Are there any water pumps on site? Are they still in use? And does anyone need to have access to them in the future? It's also worth looking what is in the vicinity of your development. Is it surrounded by open land? Are there houses, cricket or football pitches? You may want to start thinking about any foreseeable objections from your surrounding neighbours to your proposed planning application and a strategy around this. Clearly, you will be undertaking your own feasibility studies. Finally, in addition to the above, there are a few other considerations for developments in city centres which I thought I'd touch upon. These are namely rights of light. Will your proposed development pose any light injury to surrounding buildings? If so, you will need to carry out a rights to light report and survey. This will identify the properties affected and the injury in monetary terms. We would like to be involved from the beginning so that we can discuss options with you. Will it be deeds of release or an insurance policy, which is something Abdi is going to mention later? If you do have a lender involved, then they will also want some input into this, especially if you are procuring a development facility. What we are trying to avoid is the worst case scenario, which is being served with an injunction during the build phase of your development, as this will cost you dearly. The other factor are oversailing licenses. Will you need these? Will the jib of a crane oversail onto council or third-party land? Now, this is most likely in city centre developments, and we'll need drawings showing the radius and the diameter of the crane's jib to include in any oversailing licenses we need to negotiate for you. Stopping up orders. Now, if you do need these, you will need to engage with highways to procure these, and these can get very tricky with restrictions on hours and diversions in busy city centres. And finally, telephone masts on top of buildings. These are usually an income source for telecom providers, but an absolute nightmare if you need to have these moved, as they are protected under the Telecoms Code. If you have these on site, please let us know ASAP, as this could impact the timings of your proposed development. I'm now going to hand over to Abdi.
Thanks, Pam. And first and foremost, I'd like to echo Pam's warm welcome on what's a bit of a chilly day, and welcome you all to the webinar. One of the first questions I get asked when looking at potential development sites are there any red flags? Now, if you Google the words red flags, what you'll get back are a whole range of different flags in all shapes and sizes. You've got everything from small flags, which look nice and calm, to giant flags, which are flapping in the wind. Buying land's no different, because the flags come in all shapes and sizes. Some are obvious and more easy to spot, whereas others are less obvious, but can be just as problematic. Pam's already touched on some of the things to look out for when on a site visit. And over the next 10 minutes or so, I'll expand and give an example of two of those, being ransom strips and access. We'll also talk about another potential red flag, restrictive covenants, as those tend to be the first things that I look for when looking at title documents for a potential site. Keep in mind that finding the perfect site isn't always possible. More often than not, the site that you buy isn't going to be perfect, and it may well be that there are at least some residual risk that remains. The key isn't necessarily buying land with no risks, but rather being able to identify the risks early, navigating around them, and thereafter managing and mitigating the risks as low as possible. You'll want to avoid buying or even beginning to develop the site for the ultimate end user or a future lender to spot an issue that you're not aware of. So first up are ransom strips. And whether or not a site makes a good site or not is largely irrelevant if you have to cross land owned by a third party who will not give you consent. If we look at the scenario on the screen, you'll see that you found a potential new site which is currently an open field which belongs to a local farmer. The selling farmer wants to retain his farmhouse at the bottom and a small garden, but is willing to sell you the remainder of the field. You've done your site visit and everything looks fine. In this example, you'll see that the site to the north has already been developed, and there's a nice new road that can provide access. That's good because although your seller can access his farmhouse from the adopted road from the south, that isn't suitable for your development. Everything looks fine on the ground, and once that hedge is removed between the new road and your potential site, you'll be able to connect into the road. But unbeknown to you and your seller is that waiting in the wings is Mr. A, the previous landowner of the land to the north, who in due course will say that that hedge actually sits on a strip of land which he retained when he sold the land to the north, knowing that it would prevent access to your seller's field and that he'd need to be paid off to unlock the development potential. In this scenario, Mr. A potentially has a ransom strip because you need to cross his land in order to access yours. So how can we deal with Mr. A? Well, one of the first things that we do is to confirm whether the ransom strip actually exists or not and is owned by Mr. A. It's not always obvious, especially when it's unregistered land. If we're satisfied that Mr. A does own the strip, before buying the site, you'll want to make sure that Mr. A is both willing to sell or grant rights over the land and at what price. Getting to the bottom of those issues as early as possible is crucial. What you don't want to do is be exploring that post-completion. For anyone that's come across ransom strips before, you may be aware of a case known as Stokes and Cambridge, which quite often gets mentioned when dealing with ransom strips. Because in that case, the value of the ransom strip was judged to be 1/3 of the value of the uplift in land. However, what often gets overlooked in that case is that it related to a compulsory purchase and not an arm's length commercial transaction. The reality is, compulsory purchase aside, that Mr. A is under no compulsion to sell and there's no set formula to determine the price. So it's best not to proceed on the basis that Mr. A is going to sell and it's going to be 1/3 of the value. Whether a deal can be reached with Mr. A and at what price is likely to determine whether the project's feasible or not, and it clearly gives Mr. A more advantage if you've already bought the site and committed money to it. Another option that might be available, depending on the circumstances, is potentially applying to the land registry for ownership of the ransom strip and cutting Mr. A out completely. It might be, for example, that it was your seller that planted the hedge 15 years ago and he's always treated that ransom strip as if it's his own. And finally, again depending on the circumstances, and particularly where Mr. A has not yet come out of the woodwork, you could try to manage the risk by taking out insurance against potential claims by Mr. A and proceeding regardless and letting sleeping dogs lie. Insurance can be useful to manage risks like this. It doesn't get rid of the risk, but it does provide you, your funder, and or potential buyers with comfort in knowing that if the risk did materialise, that there's an insurer in the background who can help. Insurance isn't always available, and it largely depends on the factual background to the issue and who knows what. We're not insurance brokers ourselves, but one of the key conditions of most policies that we see is that you can't contact the third party, in this case Mr. A, or anyone else who might have a claim, nor disclose the existence of the policy itself to any third party, because that essentially brings the matter to light and tends to encourage the claim. So we'd advise to discuss the matter as early as possible in the transaction with your solicitor and not try and approach Mr. A first. Next, we'll look at access. To keep it simple, I've used a similar site layout to that which we've just looked at, but this time the site to the north isn't developed and isn't suitable for development. In this scenario, you've done your site visit and you're happy that there's no ransom strip. The site looks promising, but this time the access is via an unadopted older road, but your seller has said that he's got access over that road by way of a formal deed granting him a right of way. Brilliant. Everything looks good, and so you can start to spend money on planning. At some point, the owner of the land to the north, or maybe his children, if they've since inherited the land, decide that they don't like the sound of your development, and they don't want the road being used to serve anything other than the farmhouse. Certainly not commercial units, or a housing estate, although they might change their mind if the price is right. But the seller's told you he's got a formal right of way and is telling you not to worry. So how can we unlock the development potential? The first thing that we can do is review the deed that governs the right of way. That's because not all right of way are granted equally. It could be that the right was granted for use and enjoyment of the farmhouse only as a residential dwelling, rather than access for all types of vehicles or to serve a much larger development. At the same time, we can explore, notwithstanding what the formal right of way says, whether a new or extended right can be implied. In some instances, depending on your seller's use of the roadway, it might be that an implied much wider right has been established. If none of the above are helpful, we can help you to agree and formalise a new right of way with the owner of the site to the north. And again, finally, depending on the circumstances, it could be that insurance is available to help mitigate the risks. Again, as with the insurance for ransom strips, the key is discussing these matters with your solicitor as early as possible so as to not give away any leverage to any third party. And finally, restrictive covenants. You've had enough of ransom strips now and access issues, but the good news is that on the horizon is a new site which has access and no ransom strips. The only slight problem is that you've heard there's an old covenant from the 1930s which says that you cannot build more than one house on the land and you can't operate any commercial units from there. Well, first, let's just recap what covenants are. They're agreements between landowners which are designed to preserve the value, character, and enjoyment of the surrounding land by controlling certain activities or developments. Not always, but they tend to have been imposed many years ago when the landscape was much different. Like the one in this example, it's not uncommon for them to prevent more than one house being built or commercial use of the land. In this scenario, the covenant's from the 1930s, and the original landowner will almost certainly have passed away by now, and so your seller, unsurprisingly, is telling you that there isn't a problem. But again, waiting round the corner, quite literally this time, is the neighbouring landowner who says he has the benefit of the covenant, and he quite likes his view across the open field. He says that if you try and develop the land, he'll instruct his lawyers to obtain an injunction. But again, if the price is right, he might be willing to forgo that view. So what can be done? As with most things, the devil's in the detail, and the wording of the covenant is key. The first thing to look at is the covenant void? If not, who can enforce it and what's being restricted? I've acted on sites before where, on the face of it, there is what looks to be a binding covenant against development, only for it to turn out that the covenant's actually void, even when it's on the title register. There were, and still are, strict rules about registering covenants, which quite often, for some unknown reason, tended not to be followed. It could be that the land with the benefit of the covenant was at some point since the covenant was created owned by the same person who now owns the other land, which acts as a release, even though they're now owned by different people. These things aren't always obvious from the title register, and the land registry don't automatically update these things. Is the wording of the covenant such that it just binds the original landowner, or does it bind future landowners too? Where does the land with the benefit start and end? What's actually being restricted? Does a covenant which prevents building for any purpose other than a private dwelling house mean that you can only build one house, or can you build as many as you like, provided that they're only used as private houses? These are all things that we can look into. If it is valid and enforceable, can it be discharged? Even when it was properly registered and binding, there is a process that you can follow to apply for the discharge of the covenant on grounds that it's now obsolete. At the time when the covenant was imposed, the landscape could have and very likely would have been very different than it is now. Would one more development really make a difference to the outlook of the surrounding area now? It may have in 1930, but that could be a lot different now. We can also help to formalise an express release of the covenant. This might be the answer if the covenant is valid, you can identify the landowner with the benefit, and you want the certainty of buying off the covenant and can agree terms on a commercial basis. And finally, as is becoming a bit of a common theme, it might be possible to let sleeping dogs lie and explore the possibility of insurance. Again, the key is to get legal advice as early as possible in the transaction so that you can explore your options and mitigate the risk. Thank you for listening. I hope that you found that useful. Do submit any questions that you have, and I'll now pass you back to Pam to chair the Q&A and for any final words.
Thank you, Abdi. We're now going to answer some of the questions we've received. As a reminder, you can still submit questions through the questions panel in your control panel. Okay, first we've had a couple of questions come through. Okay, when is it best to instruct lawyers? The first one. Abdi, I'll answer this one. I'd advise that you engage with your lawyers right from the outset. As soon as you've identified your site, drop your lawyers an email, give them a call, let them know what you've identified. We can pull off official copies for you, find out some other basic details about the site, and also find out a bit about the planning history as well. You can then go out to do your site visit. We could accompany you to do that, but we can also then assist whilst you're compiling heads of terms and discuss deal structure with you as well. So it's always worth getting us on board right from the outset so that we can support you right from the beginning.
Another question in, are covenants enforceable if you've got planning permission? Yes, they are, and good question. We get that quite a lot. The reason being is they're two separate regimes. Planning permission is essentially approval from the local authority for you to build whatever it is that you've proposed to build, whereas covenants are best to think of them as private contractual relationships between two different landowners. So even if at local authority level, they're happy for you to build what it is that you're saying you're going to build, that doesn't stop an adjoining landowner or somebody with the benefit of the covenant, notwithstanding the fact that you have planning, coming along and enforcing that covenant. Another question, how do I find out who's responsible for the maintenance of a dividing boundary? Another good question. It's probably easier to start with what the answer isn't. And what the answer isn't is that you own the boundary to your left or right. I can never remember which way round it is that people tend to tell me, but quite often people will say that they've heard from a friend that, you know, if you stand on the road and look to the left or the right, that's the boundary that you own. That's nothing more than a myth, or we probably get called fake news these days. The answer, quite boringly, is that you have to look at old conveyances and see what happened when it is that the land got divided originally. Problem with that you tend to get, though, is that it's not always possible to find those old documents. The land registry don't always keep them. They'll sometimes just put extracts of them on the title register. Even when they do have them, the plans aren't always the best. They tend not to be drawn to scale. Poor quality, any fence or boundary line may have differed slightly now. The OS plan tends to be different. Has there been a new arrangement between the landowners since that original arrangement was created? And so it does become a bit of a minefield as to who owns or who maintains the boundary. I tend to find that typically, depending on what it is you want to do or why the needs arisen for you to find out who has to maintain the boundary, there's probably another way of doing what you want to do or resolving the issue without ironing out specifically who has responsibility for the boundary. And I find more often than not, the documents don't tend to deal with that or hit it head on. And so that might be one of those where you don't actually get the answer. And again, you know, it rolls back to you're not always going to find the perfect site and have all the answers. But the key is to find out what the issue is or potential issue is, and then look at ways to mitigate that or deal with it. And so it may not actually be pivotal to you to find out whose responsibility the maintenance of the boundary is, if it is that we can deal with or mitigate the risk that you're concerned about another way.
Thank you, Abdi. Okay, just checking the time. Okay, so I think that concludes our Q&A, and we've come to the end of today's webinar. I am conscious that we've covered a lot of ground today, but we've only really scratched the surface in the short time we've had available. There is more in-depth guidance available on the Knowledge Hub section of our website, and we will be sending you links to all the relevant information in the next couple of days, including a recording of the webinar as mentioned previously. You can watch our previous webinars addressing common business challenges on our website under our News and Insights section. Our next session will cover acquisition, where Abdi and I will talk through the different methods of buying and selling land, and we will include a link to register for this in our follow-up email. We do also have 2 other webinars coming up: the Tenant's Guide to Resolving Commercial Lease Disputes, which is on the 26th of February, and EOT as a Strategic Exit, which is on the 6th of March. So please do sign up for these if they are of interest to you. I think all that's left for me to say now is thank you to everyone for attending our webinar today. It's been great to see so many of our clients and new contacts take part. Once you leave today's webinar, you will be directed to a very short survey for your feedback. We would really appreciate it if you could complete that to help us improve our webinars going forward. On behalf of Abdi and myself, thank you for joining us today and enjoy the rest of your day.